Many thanks, Carol, for this very kind introduction. Ladies and gentlemen, in this world, nothing can be said to be certain except death and taxes. But when you are involved in construction, you know, or you should know, that there is another certainty, and the other certainty is that the works will be delayed, no matter what. Ladies and gentlemen, I've been asked to discuss with you today innovation in construction delay management. Delay is a very regular feature in construction project. Delay claims are absolutely the norm in construction projects, and it's probably one of the most complex construction law issues that exist, and that is due to the fact that the nature of the construction projects is so difficult. There are moving parts, and the inter-parties relationship is quite complex. Indeed, you have a contractual matrix where the employer appoints an architect, a civil and structural engineer, a mech and elec engineer, an assigned certifier, a QS. You have also the PPSCS, then you will have a contractor, main contractor, domestic, nominated or selected subcontractors. Under that you have then the suppliers, the manufacturers, the insurance requirements, and the bondsman. A big complex unit. It doesn't matter how small your project, these are the people you have to deal with. An Australian judge has once compared the accommodation to changes on construction project analogous to the ever-changing commands on the battlefield. He said that except in the middle of a battlefield, nowhere must men coordinate the movement of other men and material in the middle of such chaos, and with such limited certainty of present facts and future occurrences as in a huge construction project. Even the most painstaking planning often turns out to be a mere conjecture, and accommodation to changes must necessarily be of a quick, a right, and an ad hoc sort, analogous to the ever-changing commands on a battlefield. Why do we actually argue about construction delay? Well, time is money, ladies and gentlemen. Time is money. For a contractor, having to stay longer on site will bring with it extra cost, extra preliminaries, what they call the prolongation cost. For an employer, having to delay the usage of a project, it will be a loss of revenue, or having to rent somewhere else awaiting the construction being completed. The starting point with all of that is the building contract. A building contract which normally would stipulate that the works have to be done within a limited period of time. Indeed, most construction contracts will say there will be a start date and a completion date, and if you fail to complete on time, there will be damages. Now, if you say nothing, then the employer is entitled to the general damages, which essentially means that the employer has to prove the damages, or you use liquidated and ascertained damages, whereby you specify in advance a genuine pre-estimate of your loss going forward. And it's a very complex area. There's loads of case law on what makes an LAD enforceable or not. Now, speaking of case law, let's have a look at the case law. And the very first case law that I'm aware of that deals with construction delay is Holm and Gooby. 1838, and still extremely relevant to date. Why? Because this is a case whereby the plaintiff was a carpenter, was to do work in Liverpool, and was to do some work there, and had to do the works in 4 months. 4 months. The works had to be finished by the 31st of August. Now, it didn't finish on the 31st of August for various reasons, some caused by Mr. Holm himself, but other by the brewery. Gooby didn't allow Mr. Holmes into the site for 1 month. Okay, so the court dealt with that and said that the builder was entitled to financial remuneration for having to stay longer on site. This went into appeal, and in appeal the judge said, and these are the important words to remember, if a party is prevented to complete a contract with a time limit, he is not liable in law for the default of failing to complete on time. And if there is nothing in the original contract to show that the parties entered into a new contract by which to perform the works within 4 months, at a later period, if there is no provision for that, then time is at large. Now, those are the two terms you need to understand if you're dealing with delay claims. First of all, we're introducing the prevention principle, which at its basic is probably very simple. A party cannot rely on his own wrongdoing. An employer cannot rely on owner-caused delay and then still apply for the LADs. There's a bit of a biblical type of idea here, but as much as it is biblical, it has to be interpreted, and it became probably it has been elevated to one of the most complicated matters in construction law. The second words we have here for the first time, 1838, is that if you don't have a mechanism that allows to extend your period of time, time is at large. That means that the contractor can finish the job within a reasonable period of time, and it's up to him to decide what that means. The next case we'll find there is Dodd and Churton, which again, the plaintiff is a contractor, is to carry out the works by a certain date, failed to do so, and liquidated damages applied. In this particular case, what it was that the architect asked Mr. Dodd to do extra work, which was not provided for in the contract. So what we know, a variation, a change. The contract provided for variation and change. And what happened in that case was that the judge, again, quoted that it is a well-recognized rule that was established by Holmes and Gooby to the effect that if a building owner has ordered extra work beyond what was specified and it actually then does not allow him to finish the work on time, he is not, the owner is not, is therefore disentitled to claim the LADs. Fast forward to 1970, we then get peak construction case, often referred to as the peak effect. Why? In the peak effect, we can see that the judges are not comfortable with this idea that if there is one owner-caused delay, no matter how small, that automatically then time is at large unless the contract provides for it. You could see that there is kind of an idea to bring in this idea of fault, culpa. There has to be a breach of contract from the employers to do so. But we then are in 2007. In 2007, we get one of the Wembley Stadium construction litigations, many construction litigations in there, where Mr. Justice Jackson of the Technology Construction Court, which they have in the UK, but we don't have, specialized in construction law and therefore very important to us, has specified that no, there has to be no fault. Okay, and he does so in the multiplex case by referring another case which refers to Lord Denning. And Lord Denning, again in his great simplicity, states that it is well established, it is well settled that in building contracts and in other contracts too, when there is a stipulation for work to be done in a limited time, if one party by his conduct may be quite legitimate conduct, such as ordering extra works, renders it impossible or impractical, for other parts to do the works, well, then he won't be able to claim liquidated damages. Okay. The important element here is that in the Honeywell case, the judge emphasized and explains the importance of an extension of time clause. And he explains that the extension of time clause is in favor of the employer because it's a mechanism that allows to extend the completion date, to put it further away if there is an owner cause delay. And that is good for the employer because that puts the prevention principle at bay, and it also makes sure that the contracts are not at large. Very important clause to have. Attached to that, you then have a notice clause whereby the contractor, best place, must notify the employer that there is an owner caused delay, and that it will therefore avoid the principle of the prevention principle. Contractors have tried, contractors are very clever, and they've tried not to provide notice and then said that the extension of time provision is not it's not working, and because it's not working, they would be entitled to have the time set at large. You could see that they were therefore trying to benefit of their own wrongdoing. Prevention principle applied by two. But in Australia, this worked in the Gaymar case, but not in the UK, and I doubt very much this will be applicable in Ireland. So I won't go over the concurrent delay. I want you to explain the burden of proof in a delay claim is you have to prove cause and effect, you have to prove financial loss, there has to be financial loss, and all of that has to be done on the balance of probability. Now, there's many methodologies that you can use. The Society of Construction Law protocol has specified 6 types of methods of analysis, but the court, ladies and gentlemen, want common law, common sense, which means contemporaneous data. And that's, ladies and gentlemen, what we need to have the attention for: contemporaneous evidence. Innovative techniques that visualize construction delays through digital evidence that are admissible in court is my next step. It has to be admissible in court. Now, we all know construction cameras. It's very easy to put a construction camera that can film what's going on the site. It's very cheap. There's many methods. In fact, you use your own little cameras and you can do it. But that doesn't mean that what is filmed can be used in court. First of all, if you use CCTV cameras, you have to have it installed by a recognized private security authority license. The PSA has to provide a license. No license, you can't use it in court. You have to use the native format. We've seen with what is happening in America how you can change photographs. The court wants to have the native format of what is filmed, okay? So it cannot be amended, which means you can't send it from the camera through the cloud and have it registered somewhere else, because by doing so you're compressing it in order to send it. Compressing is an amendment. You can't do. If you go and collect it from the site on a memory stick to make sure that the native format is kept, you have to have a chain of custody where you clearly explain where that is going. The information has to be, does not contain any information of personal data. You shouldn't be able to recognize anybody. People say, don't worry about it. We have passwords. You can't get at it. No, GDPR doesn't care about passwords. If the information is in there, then it's not permitted. So how do you deal with that? Well, very high resolution cameras are so highly pixelated when they are stored in their native format that you can't see anything. You need another program to see it. The other aspect is if you have it in such a way that everybody can have if you can ask the discovery of all that data, that might not be what you would like to do. So there has to be a mechanism there which allows perhaps that the discovery is not due, and I'll come back to that. the person has to provide an affidavit to explain that that's in the job that he normally does, is to actually record those data. And the data has to be recorded outside, but also inside, because that's where mech and elect jobs are done. And inside needs to, you can't see through a wall, so you need to have cameras that goes inside, and also over the side to see what is happening from all angles. So now it becomes a little bit more difficult to comply with all those requirements. And a photograph on its own does not illustrate any progress. It's just a snapshot. So now you need to link this data to a BIM model, not a very complicated BIM model as Ralph will discuss with you, a BIM model that will show as planned in kind of Lego blocks, okay? Then you can see the elements of construction of where we're supposed to be versus where we are. We see this, but that's not enough. You need the sequencing, and the sequencing is you synchronize all that to the program. So that is a triptych approach. You know, the triptych, like the old Flemish primitives painted things and told a story. Well, now we need camera, BIM model, and synchronized program. And a program changes all the time. So we need to have the latest program handy, which is very important to be able to have. Is there a company that does this? Well, I thought nobody did it. There's many construction cameras, but I'm delighted that in Ireland, there's one company that does it. And this is just happens to be that it is in Ireland. I see that this company is actually going further to the UK as well. But the advantage of this company, OnRecord Limited, is effectively what they do is they do this the triple approach, whereby they film inside, outside, over, they link it to a BIM model, and they link it to a program. Now the importance is they will not act for the employer, and they have nothing to do with the design team or the construction team. Most of the time they act for the employer's legal team. Not obliged, but most of the time they do so, and they do so with the dominant reason that it's used for a claim, if a claim comes, and it's with the legal team paid by the employer to avoid discovery. So I thought that was actually quite clever. The other aspect is that if the employer, unfortunately in delay claims, has to sue the architect, the engineers, and the contractor, because that's what you do, you want to bring them all under the Civil Liability Act, you want to bring everybody that could have been the cause of the delay together. If you're the employer, you don't have the data to actually prove that the delay claim has no merit. That's why it's good to have this extra person that can provide you with that information. This person, this company that you might appoint, as I said, OnRecord Limited, but I'm absolutely sure many others will follow suit, is a record handler. They will handle the contemporaneous data. They are not the project manager, no. But they might provide the information to the project manager if the employer so wishes, but they are not an alternative to the project manager. They just handle the data, they keep the data, and how it's interpreted is not their job. Their job is to make sure that we have evidence that can be used in court, and that is important to manage the delay claim, because again, it's up to you to prove that what the contractor is claiming against you has no merit. It is up to you to prove that with contemporaneous records. Thereafter, you can go to experts, delay analysis experts that will talk about critical path and all those very complex cases, extremely expensive, but you can do that. The court still wants to see the contemporaneous evidence that has not been altered, that has been obtained in compliance with all legislation, not just lip service, real, and all of that is a possibility you now have whereby you can see the photos, real photos unamended. You can see the BIM model that shows where you're supposed to be in a particular time and the sequencing that was there. All that information is there, and it's now up to the lawyers to explain to the judge or the arbitrator whether the delay has merit or not. Now, ladies and gentlemen, thank you very much, and if you have any further questions, please do not hesitate to ask me. Thank you.